So good morning, good afternoon, everybody who is joining us today. First, we hope that everybody is safe and well during these rather challenging times. And please don't worry about any children's dogs, cats or partners interrupting. It's the new reality we have. Looking positively, the pandemic has seen the increased use of virtual meeting platforms and has enabled us to come together today. Something potentially that would not have occurred on such a scale and across so many jurisdictions before. So our thanks go to all of the attendees for convening with us for this, the first public review and discussion webinar following the issue of the white paper on the 24th of March of this year, copies of which are available on the Human Rights at Sea website underneath our publications area. We also appreciate your tenacity in sticking with the event after an earlier and indeed unexpected but necessary administrative postponement. And I would also like to extend my sincere thanks to our partners in this venture, Shearman Sterling and the Paris-based arbitration team, led by Banifatemi and Alex Marcopoulos. And of course, the team comprising Elise, Sandrina, Masha and Nanu. So thank you for their continued support and indeed extensive professional and personal investment in this project to date. Again, we would not be able to do this today without their professional backing from the firm. In terms of housekeeping, obviously if there's a loss of link, please log out and come back in. And we have our own tech guru, Benoit, keeping us up and running. There will be a Q&A box that will be open for participants. Please submit your questions that are pertinent to the event. And of course, questions are always always that text which ends with a question mark. May I just gently ask us to avoid any politically orientated questions as we really are focusing on a victim-led approach to effective remedy in the maritime space. If you have complete loss of access, the good news is the event will be recorded, it is being recorded now, and will appear on the Human Rights at Sea website along with the presentations that you will see today, and that will be up and running as soon as we can do so. Also, the project team's email addresses are on the Eventbrite site and any press releases. In terms of follow-up, everybody who is registered with the Eventbrite site will indeed receive a follow-up email with all the links and videos. So today we have quite a extensive webinar structured. After my introduction, and I will hand over to Alex, we will have two panels. There'll be breaks in between and then a Q&A. And we really do ask you to, as much as you're able to, get involved with the questions and indeed any follow-ups by email afterwards, because we are doing this as a collective and a transparent process of collective experts coming together. The first panel is exploring how arbitration could be used to address human rights issues. Panel 2 is all about consent as the cornerstone for Human Rights at Sea's arbitration proposal and key issues that are being brought up at this stage, this early stage, and possible solutions. Our two moderators, Elise Edson, who's a senior associate at Shearman Sterling based in Paris, will also be joined by John Gaffney, Senior Counsel at Al Tamani and Co-Firm in the UAE. So welcome to them also. In terms of documentation, all of our documentation is transparent, it's available online, and again, this is part of our iterative development process. The white paper is in both English and French, and we aim to have it in more languages as we develop the follow-on versions. And shortly to be available will be Senior Shipping Counsel's opinion, that is James Turner, Queen's Counsel of Quadrant Chambers in London. So, setting the scene of the webinar today. I will set the context and the background of the event. You'll be pleased to know there's no slides because I'd just like to get the advocacy across to you. And we aim this to be the first of a series of follow-up events as we move forwards to evolve what has really grown from the genesis of an idea that came to mind during a shower, sketched on a napkin en route to Abu Dhabi in October 2019, and proposed in an introductory email to the Paris arbitration team. The rest is history, And today we are really getting down to the detail. Before we go into the actual project itself, which Alex will cover in detail, I just wanted to take a short moment to give those who are not familiar a background about human rights at sea. The idea came in 2013 and was first proposed at the first London International Shipping Week in September 2013. The organisation was established in April 2014, and in May 2015, we became a registered charity here in the United Kingdom. Today, we're in year 7 of our work. The founding principle of the organisation is very simple. It's that human rights apply at sea as they do on land. And you will hear me talk about that more than once today. Our vision is to end human rights abuses at sea. And we are an advocacy organisation and not a welfare organisation, but a lot of those welfare issues overlap, and we work very closely with all welfare and other organisations who share our founding principle and indeed vision. Our baseline framework is based on the Universal Declaration of Human Rights, 1948, with our own core principles bound into that of transparency, clarity, and accountability. And a final point before I get into the project itself is that human rights at sea as an NGO really shouldn't exist today. We have labour rights, we have women's rights, we have child rights, but as a matter of fact, as a civil society platform, we did not have human rights at sea in 2013. Today, we are engaged with by states, flag states, commercial entities, civil society and academia. And in many respects, we have already started to achieve our aim and our vision through the increasingly wide adoption of those 4 words, human rights at sea, into the common lexicon. So as I said, we orientate our work at human rights at sea through the 30 articles of the 1948 Declaration. Itself, the result of the worst excesses of national and international armed conflict in the early to mid 1900s, and really a direct result of the rise of nationalism. The promotion and application of human rights are really consistent with liberal democratic values and with that liberal frame of mind. Obviously, they're not so prevalent in any meaningful sense in authoritarian jurisdictions where control of citizens is more of a priority, and of course, which we do not subscribe to such a repressive approach to human rights. The foundation of our work really does revolve around that founding principle. And that principle that human rights apply at sea as they do on land can only work where there are state protections for the citizens and those states respect international law norms. In our human rights work for our organisation, there are the victims of abuse, of repression, and of the failure to provide access to their fundamental rights with routes to effective remedy. And by way of a segue, that brings us really into the project. So the initial concept was that in addition to all other available routes, including civil, criminal, internal complaint systems to achieve effective remedy for victims who have suffered human rights abuse within the maritime environment, the established routes to remedy in our proposal could be used through an arbitration process that could be adapted into the field of human rights protections and indeed remedies. We note very clearly there are existing mechanisms, but we also note that they may not necessarily achieve justice for victims, and it is this that we need to address. We also note that the protection of the human rights of a citizen is a state responsibility, though as we are increasingly seeing with the likes of the 2011 UN Guiding Principles on Business and Human Rights, business is indeed taking responsibility for respecting national and international human rights provisions and indeed providing corporate routes and transparent routes for remedy in terms of complaints. For those of you who've not actually had an opportunity yet to read the white paper, I am just going to very briefly run through the introduction and the paragraphs, the first 5 paragraphs, again to set the context. So from the white paper, The United Nations defines human rights as rights inherent to all human beings, regardless of race, sex, nationality, ethnicity, language, religion, or any other status. The philosophy of human rights at sea builds on this basic definition to add the following 4 core principles. Firstly, that human rights apply at sea to exactly the same degree and extent that they do on land. That all persons at sea, without any distinction, enjoy human rights. Thirdly, that there are no maritime specific rules allowing derogation from human rights standards. And finally, that all human rights established under treaty and customary law must be respected at sea. At present, these fundamental principles are not being adequately respected, complied with, or enforced at sea. Widespread and systematic human rights abuses continue to occur at sea, including slavery, abandonment, sex trafficking, sexual assault, and deprivation of basic labour rights. That these issues have persisted or indeed even worsened, notwithstanding the existence of a well-established body of international human rights law, indicates clearly that human rights abuses at sea require special attention. This is especially true of human rights violations on the high seas, where policing and enforcement of human rights violations is all the more difficult. A concomitant of the chronic state of impunity and lack of accountability for human rights abuses at sea is the lack of effective remedy for victims. Despite the existence of a number of well-developed human rights mechanisms at international, regional, and domestic levels, the reality is that victims of maritime human rights abuses are not accessing these existing fora in any significant numbers. The vast majority are therefore left without a remedy. An arbitration-based mechanism of redress for human rights abuses at sea would address both the procedural and the substantive dimensions of a victim's right to a remedy. It would do so by providing, first, a neutral and visible forum in which human rights issues could be resolved. Second, a procedure that is both efficient and financially accessible to victims. Thirdly, an adjudicative process that is highly specialised and tailored to the sensitivities of human rights issues, as well as to the particularities of the maritime space. And finally, binding arbitral awards that would be enforced internationally. So that's the introduction to the white paper. My first headline is that we are at the start of a victim-centred project exploring the possibilities of the use of arbitration and concept for effective remedy for human rights abuses at sea. This is by far not a finished or polished concept, and it will rely on positive and detailed expert engagement throughout this project for it to be a success. Some of the challenges. Well, first of all is the sell of the concept and the project, its structure, garnering international acceptance and engagement with such a newly proposed tribunal. There will be industry challenges of perceived ownership of the concept and the platform. There are issues about maintaining independence, achieving consent to arbitrate, developing contractual terms and conditions accepted by employers. Finally, there's issues around tribunal funding and panel constitution. And to be clear, this is not being established or attempting to be established to make lawyers richer, but to provide victims with a voice, support, and remedy. My second headline is that the main factor that would impede success and overcome the issues of the project, which I'm sure there will be many, would simply be attempts by vested interests to prevent or indeed roadblock this development. As we all know, constructive criticism is both necessary and indeed welcome, but we can only work with like-minded individuals and entities who are indeed seeking innovative solutions for long-term social change at sea. Today, we're going to explore the art of the possible with a cohort of subject matter experts coming from legal, academic, flag state administration, and banking sector backgrounds, noting that in the latter case, without funding from the Ethical Finance Centre, global corporations simply cannot undertake lawful business at first instance. So as I start to wrap up, I'm not going to steal the thunder of our moderators, Elise and John, And I'm going to therefore leave them to introduce their panelists respectively. And finally, from myself and from the team at Human Rights C, we would again like to sincerely thank all the attendees for giving up your precious time to listen to us and our positions in relation to what we hope will eventually become a workable solution for greater success to provide justice for victims of human rights abuses at sea. Thank you very much.